Hearsay can be much better evidence than direct, as we have learned in painful instances, and it's certainly valid in this instance.
No. Viva Frei, Montreal litigator turned YouTuber, and it's vlog time. That opening scene, incidentally, is from Billy Madison, perhaps the greatest comedy in the history of humankind. Undoubtedly Bradley Whitford's most compelling performance ever as Eric before he hit the big time on The West Wing. Alright, but enough pop culture references, it's time to talk about the impeachment hearings. For those of you who've been living under a rock, the impeachment hearings summarized in one breath. Let's see if I can do this. There have been renewed calls for the impeachment of Donald Trump as a result of a phone conversation he had with the president of the Ukraine, Zelensky, in which it is alleged that he engaged in an impeachable quid pro quo, withholding aid for military stuff, in exchange for which the Ukraine would confirm that they would renew an investigation into Joe Biden and Hunter Biden's son for the role he played in Burisma Holdings. Okay, that's pretty darn good, and I'm not giving that a second try. The underlying argument is that this is an impeachable quid pro quo because Trump was pressuring Zelensky to dig up dirt on a political rival and withholding some $400 million in aid that was approved to be dispersed to the Ukraine. The first public impeachment hearing inquiries occurred the other day, although there was behind closed door testimony a couple of weeks ago. And the first two star witnesses in these public impeachment hearing inquiries were George Kent, Deputy Assistant Secretary of State, and Bill Taylor, the U.S. Ambassador to the Ukraine. And I know some of you are getting irritated at my use of the Ukraine instead of Ukraine, but it is arguable which one is proper, and I prefer the Ukraine because it sounds more the official. And although these hearings for the most part are nothing more than political grandstanding and political theater, they are nonetheless educational to watch from a legal perspective. But first things first, let's just explain what the impeachment inquiry is all about. Contrary to public misconception, impeachment does not mean the removal of a public officer from office. To draw an analogy to criminal law, the impeachment is sort of like the indictment. It is not the conviction itself. So the impeachment would be like the indictment of the president to be removed from office, but not the actual removal of the president from office until the impeachment has been approved by the Senate. And this is how it would work. The House would vote to approve impeachment articles. Going back to the criminal law analogy, the House would basically vote to approve the indictment. The trial on the indictment then goes to the Senate. In order to approve the articles of impeachment or the indictment that would then be submitted to the Senate, it only requires a simple majority of the House. If or when the articles of impeachment, the indictment, are approved by a majority vote in the House, they are then submitted to the Senate, where in order to be convicted, it requires a 2/3 supermajority vote by the Senate. We are now getting the public inquiry, which is the political grandstanding that goes along with these hearings, as the underlying sort of mini trial to determine whether or not the House is going to approve articles of impeachment to then submit them to the Senate. There has been no impeachment yet. There have been no articles of impeachment approved. Right now we are just having a public inquiry, which is going to serve as the basis for the House voting on whether to approve articles of impeachment, which they would then submit to the Senate.
And the hearing is a show.
Now, full disclosure, I have not and probably will not watch the hearings in their entirety. There's just too much of it and it is just too tedious, but I have had it running in the background and I go to YouTube to watch the highlights. And yesterday I saw a highlight of highlights.
I guess to close, primer on hearsay, I think the American public needs to be reminded that countless people have been convicted on hearsay because the courts have routinely allowed and created needed exceptions to hearsay. Hearsay can be much better evidence than direct, as we have learned in painful instances, and it's certainly valid in this instance.
Well, gentlemen, yield because none of those exceptions would apply to this testimony.
Quigley. No, not that Quigley. Representative Mike Quigley publicly affirming for the benefit of the nation that there are times when hearsay evidence is actually better than direct evidence. I am 1000% open for public discussion on this question, and if there's anyone out there who vehemently disagrees with the statement I'm about to make, please leave a comment in the comment section below as to why.
Never is hearsay evidence better than direct evidence, period.
Typically, people understand hearsay evidence as being someone told me something and now I'm telling it to you without having that person say it directly. And that understanding of hearsay evidence is accurate enough for all intents and purposes. But hearsay evidence is either a written or verbal statement made out of court but presented in court to prove the truthfulness of that statement. And it is generally considered to be inadmissible. Why? Because you don't get to cross-examine the person having made the statement on the truthfulness of that statement. And that is why you have the dichotomy between hearsay evidence and direct evidence. Hearsay evidence, by definition, is not direct evidence, it's indirect evidence. Incidentally, I've done a few videos on the subject right now. I'll post the playlist right here. And another YouTube lawyer named Legal Eagle also did a full video on the hearsay exception. But hearsay is just that. It is an exception. It is only under certain well-established legal exceptions that hearsay as evidence is admissible as opposed to direct evidence. But to give Representative Quigley the full benefit of the doubt, I can really only think of one example where hearsay evidence is actually better than direct evidence, and that would be when the person having made the statement is dead. Yes, you will never again be able to get direct evidence or cross-examine the person who made the statement, so you may have to rely on the exception of hearsay. Another example might be where if disclosing the identity of the witness, you would compromise their safety, so it's better to rely on a written statement as opposed to viva voce testimony. But even then, the hearsay evidence is not better than direct evidence. There just might be an exception as to why it would be admissible. And even then, it wouldn't be a question of circumventing the fundamental right to cross-examine the witness on their statement. It might just be done in other means that would not require disclosing the identity of the witness. So no, and please, somebody correct me if you think I'm wrong, there is no circumstance in which hearsay evidence is better than direct evidence. But that is not the only lesson in law that we can take away from Quigley's examination of the two witnesses. And whether or not you agree with this or approve of it, it is nonetheless a fact. These impeachment hearings are drawn on political lines. In theory, it should be about justice, it should be about the truth, etc., but in reality, it is purely political. And so with that in mind, these witnesses are going to be either hostile or friendly witnesses depending on who is examining them. When a Democrat is examining Kent or Taylor, they are basically treating them like friendly witnesses. They have the same end goal and objectives in mind. And that is why we see the Democrats asking the witnesses what we call leading questions. Compare that to when Republicans are asking them the questions and you see that they have diverging interests. Taylor and Kent, as the end goal, have in mind the impeachable quid pro quo, whereas the Republican doesn't necessarily have that same goal. And it is reflected in the manner in which the Republicans are asking them the questions. Republicans are treating them like hostile witnesses, Democrats are treating them like friendly witnesses. But even in treating them as friendly witnesses with leading questions, Quigley had some serious problems with his examination.
So it's interesting and curious that we're talking about hearsay evidence. It is extraordinary to me that the committee's been able to get as much information as they had, direct or hearsay, given the obstruction. All right, 23 seconds without a question, and all that we have is the affirmation of what would undoubtedly be a disputed fact of obstruction. This is the definition of political grandstanding. Both sides do it, so this is not an attack on the Democrats. Both sides do it to some extent, and that is why people largely view these hearings as nothing more than political theater. Okay, back to this video. You gentlemen were both asked by the State Department not to appear for your depositions, is that correct? That is the definition of a leading question, a question that you invite the witness to answer as yes or no. Typically, when dealing with your own witness, you're not allowed asking them leading questions because they are supposed to know their own story without being coaxed by their attorney. In this case, because the interests of these witnesses are aligned with Representative Quigley in the ultimate goal of impeachment, they are basically friendly witnesses and in theory should not be asked leading questions. Okay, opening up a parenthesis, I appreciate that the rules of procedure or the rules of evidence are not the same in these impeachment inquiry hearings as they would otherwise be in the standard court of law. And when I'm talking about the appropriateness of asking leading questions, it's not to determine the admissibility of the evidence. Bear in mind that if you ask your own witnesses leading questions in a court of law, the opposing counsel can object to those questions and a judge cannot allow those questions because they are leading. So, for example, you ask your own witness, ooh, and I bet that made you feel very bad and you found that very hurtful. Objection, leading question. And a judge can say, no, I'm not allowing that question as formulated. Rephrase the question so that it is not leading. Rephrase it, for example, so how did that make you feel? And so, for example, when Quigley is examining Kent and Taylor, if he has to ask them too many leading questions, it sort of undermines their credibility as far as the story goes that they're trying to tell. So I'm not making these observations as a question of admissibility of evidence, but rather just as relates to the credibility of the witnesses. Back to the video. Basically, leading questions are structured such that the questioner is making an affirmation and asking the witness to agree with it. You gentlemen were both asked by the State Department not to appear for your depositions, is that correct?
We both received, I believe, I received initially a letter directing me not to appear, and once the committees issued a subpoena, I was under legal obligation to appear, and I am here today under subpoena.
Ambassador, were you also asked not to be part of the deposition?
Mr. Quigley, I was told by the State Department, don't appear under these circumstances. That was in the letter to me, and when I got the subpoena, exactly as Mr. Kent said, that was different circumstances and obeyed a legal subpoena. So that, yes, sir, I'm here for that reason.
Absolutely.
And even with that, the witness does not provide the answer that I think Quigley was after. If this is your witness, you may not be happy with the answers they have provided because it doesn't actually confirm the statement that Quigley inserted into his leading question. Moving on.
We were not able to hear testimony by Chief of Staff Mulvaney, John Eisenberg, Michael Ellis, John Bolton, more than a dozen witnesses. So I suspect if you have a problem with hearsay, you'd have a lot more direct testimony and direct evidence if you weren't blocking that ability. You'd have a lot more documents that you referred to with my colleagues' questions that have not yet been turned over by state or any other agency. Is that correct to your knowledge, gentlemen?
That is something of a 35-second convoluted statement of opinion, and then he is asking the witnesses to agree with it. Now, incidentally enough, Quigley might be making some legitimate points as to which witnesses were told not to come. But that is one heck of a lengthy, convoluted statement to then ask the witnesses to confirm.
You'd have a lot more documents that you referred to with my colleagues' questions that have not yet been turned over by state or any other agency. Is that correct to your knowledge, gentlemen?
We're both here under subpoena. I don't think either of us is going to comment why others have not shown up.
And the witnesses cannot even confirm the grandstanding statement that Quigley just made and ask them to confirm. This is not how you conduct an examination, and it is certainly not the answers that you want from the questions you're asking.
Following the July 25th call and through the first 2 weeks of August, were you involved in any efforts to arrange for President Zelensky to make a statement announcing the two investigations that President Trump had talked about in the July 25th call?
I was not, and I would never participate in an arrangement to have them announce investigations.
Ambassador Taylor, were you involved in any such efforts?
No, sir.
All right, now bear in mind that Quigley is trying to make evidence of a quid pro quo, and that being that Trump asked for Zelensky to do certain things in exchange for which he would release $400 million in aid. And if you listen to the witnesses' answers, they're not actually confirming that it happened, but they had no part in it. They are in fact confirming that they had nothing to do with any such thing, which may in fact exonerate them, but doesn't actually inculpate or make evidence of an impeachable quid pro quo. This is not a defense of Trump or any accusations of an impeachable quid pro quo. This is just to show that the questions being asked are leading to answers that do not make evidence of the impeachable quid pro quo. This may exonerate the witnesses, but they have yet to make any evidence of any wrongdoing that would have inculpated them in the first place.
Andre Yermak says that once we have a date, they will announce the investigations in bereavement and election meddling. Mr. Kent, are these the same two investigations President Trump asked the Ukrainian president to initiate in the July 25th meeting, 25th call?
Those appear to be the same issues that were mentioned in the call, as well as the media campaign that started in March, led by Rudy Giuliani.
Those appear to be. Now that is a very important qualification, and why? Because it is hearsay, because Kent himself does not have direct knowledge of that fact. Quigley is asking Kent a question that he simply cannot answer by first-hand knowledge. Take it for what it's worth, especially in light of Quigley's previous statements that allegedly there were certain witnesses that did not come who might have been able to give first-hand knowledge of it, but appreciate that that is hearsay evidence. And it is not necessarily as strong of an answer as Quigley would have wanted.
Mr. Kent, as the day-to-day State Department point person in Washington on Ukraine policy, were you aware of this effort to persuade President Zelensky to issue a statement in order to get a White House meeting while they were happening?
When this exchange happened on August 10th, I was not.
When did you learn about them?
As Ambassador Taylor referenced earlier in his testimony and oral answering, he heard on August 16th, he then called me and we had a conversation, and at that point I memorialized my concerns in a note to the file.
And you have to fully appreciate the extent of the hearsay in this answer. Kent is being asked when he became aware of pressure that was put on President Zelensky. His answer is that Bill Taylor heard from someone else.
As Ambassador Taylor referenced earlier in his testimony and oral answering, he heard on August 16th.
Then relayed that information to me.
He then called me and we had a conversation.
And I memorialized my concerns with it.
And at that point, I memorialized my concerns in a note to the file.
Someone told it to Bill Taylor. Bill Taylor told it to me. I put it in a memo for whatever the reason, and and that is the evidence of the impeachable quid pro quo pressure on Zelensky that they have as the basis of this impeachment inquiry. Given the fact that Quigley knows or ought to know that these are going to be the answers, these are not good questions to ask because they are simply not making any evidence of the impeachable quid pro quo. I memorialize my understanding of what someone told Bill that Bill told me and put it in a memo. This is like broken telephone, not evidence.
Ambassador Taylor, as the point person on the ground in Ukraine, were you aware of this effort to get Ukraine to issue this written statement in early August?
Not the written statement, no, sir. No, sir.
Another answer that Quigley doesn't want. Quigley is making certain affirmations in his questions and then asking the witnesses to agree, and they're not agreeing with his affirmations. Why even ask that question? It's not like it makes the statement any more true. It just shows that the witness can't even confirm it, which sort of undermines the question to begin with.
So the entire discussion about a public statement about the two investigations President Trump wanted was done in what you have described as an irregular channel involving Ambassadors Sondland and Volker, and they tasked to take on Ukraine policy by the president. Isn't that correct, Mr. Kent?
That would be my understanding.
Ambassador?
The same.
That would be my understanding. The question is, isn't that correct? Which is typically yes or no. The answer is not yes or no, and it's not even that is my understanding, it is that would be my understanding. If I were cross-examining that witness, I would be having a field day with that answer. That would be my understanding? What would your understanding be conditional on? What exactly would you need in order to make that your actual understanding? Political affiliation aside, these are weak questions and they are even weaker answers.
I guess to close, primer on hearsay, I think the American public needs to be reminded that countless people have been convicted on hearsay because the courts have routinely allowed and created needed exceptions to hearsay. Hearsay can be much better evidence than direct, as we have learned in painful instances, and it's certainly valid in this instance.
No. I don't think very many lawyers are going to agree with that statement. People may have in fact been convicted on hearsay evidence. For example, the person right before they died said, "Steve did it." They can't be cross-examined at court, and that is technically a hearsay statement. But people being convicted on hearsay evidence is the exception to the rules on evidence and not the rule itself. And my ears always perk up when I hear statements like, people need to be reminded of.
I think the American public needs to be reminded that countless people have been convicted on hearsay.
Because in law, most of the time when someone says that, they're not trying to remind you of something, they're trying to convince you of a disputed fact. Anyhow, I think that is enough of a dissection of this particular examination, just to show you that when you're examining even a friendly witness, you have to think about your questions, especially since you should know the answers to them, and then make decisions on what questions to ask. In law, you don't score points by asking loaded questions that the witness doesn't in fact confirm. You in fact lose credibility by doing that. If these hearings are good for one thing other than wasting taxpayer dollars, they are in learning how to examine witnesses, both friendly and hostile. Incidentally, if you want to watch the other videos on this Trump impeachment subject, I'll post a playlist right here. If you like my videos and my content, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. If you want to support the channel, PayPal link up here, merch links in the comment section below, and now you know your vlog. Peace out. Booyah!